The board's rule also grants union organizers unprecedented access to employees' personal information. These are by no means modest changes, and they go far beyond simply modernizing the election process. In truth, the board's real goal is to dramatically tilt the outcome of elections in favor of union leaders by ambushing employers and workers without allowing them to fully understand their decision. The American people are on the losing end of the board's extreme culture of union favoritism. Mr. Taubman.
Thank you. Thank you for the opportunity to appear today. I have been practicing labor and constitutional law for 32 years on behalf of individual employees only at the National Right to Work Legal Foundation. I have a unique perspective on the NLRB's ambush election rule, which comes from decades of representing thousands of employees subject to the National Labor Relations Act. I have represented employees in countless elections arising under the NLRA, both certification elections, decertification elections, and deauthorization elections. I start today with the premise that only employees have rights under the National Labor Relations Act. The Act is not about unions or employers. It is about employees making free and informed choices. Given the centrality of employee free choice, I would like to address two major issues today. The first is the way the NLRB's new ambush election rules skew the process to wholly favor unionization while invading employees' privacy and depriving them of their Section 7 rights to choose or reject unionization in an informed and thoughtful manner. The second issue concerns the way in which the ambush election rules continue the odious practice of blocking decertification elections to entrench incumbent unions, while simultaneously speeding certification elections. The NLRB's new ambush election rules contain aggressive procedures to help unions win elections and get into power while hypocritically retaining blocking charges and election bars that make it almost impossible for employees to exercise their rights to rid their workplace of an unwanted union. First, the ambush election rules mandate a serious invasion of employees' privacy. They force employers to disclose to unions employees' personal, private home or cell phone numbers, personal email addresses, and work schedules, including for employees who may well not be in this bargaining unit and who may never be in a bargaining unit, including supervisors. The union gets all this information without even knowing whether these employees are in or out of the unit. Despite employees' pleas to the board cavalierly brushed aside all privacy concerns, creating illusory or toothless remedies for union misuse of employees' personal information. While Congress has mandated do not call lists and other consumer protections against spam and internet abuse, the board has refused to apply those principles here and refuses to allow any employee to opt out of the forced disclosure of his or her personal information. The board places no real restrictions or safeguards on how unions can use or disseminate this information. The only way to protect employee privacy is for the NLRB to not compel the disclosure of employees' private information. Indeed, the American public would be appalled if they knew that the U.S. government was forcing disclosure of their personal information to groups like the NRA or ACORN or the Sierra Club. But the NLRB has issued an edict doing just that for the benefit of a few politically active special interest groups called labor unions. Secondly, I want to discuss the fact that this ambush election rule cuts employees out of the process. Employees have no right to intervene in any election that is called, no input into the scheduling of the election, no input into the conduct of the election, no input into the scope of the bargaining unit, and no input into their own inclusion or exclusion from the unit. They cannot file objections or challenges to a tainted election, and their voices are silenced by these rules. For example, many employees may be unaware that a union organizing campaign is even underway in their shop until they're notified of an impending election just days away. But if these employees, even a majority of them, seek a delay in the election so they can learn more about both sides and the effects of the unionization, the NLRB will deny their request. If they ask for clarity as to who will be included in the unit, the NLRB will deny their request. If they want time to research the union that has targeted their bargaining unit, the NLRB will deny the request. All of these flaws were pointed out to the NLRB in comments that we and others filed, yet the concerns were all ignored and brushed aside. This is no way to run a democracy. It is akin to a mayoral election in which it is unknown, either before or after the election, whether up to 20% of the potential voters are inside or outside of city limits. In conclusion, we urge the committee to vote to override these NLRB rules.
Thank you, Mr. Taubman. Drill in on one point you made. I'd like to ask Mr. Taubman a question about this. The information that this rule would require to be provided on personal information on employees, is there any protection that the NLRB is afforded to the employees for what happens to that information once it's disclosed?
What the rule says about protections is illusory, useless, and non-existent. There are no protections for the use of this information that the NLRB is going to provide whatsoever, and there's no right to opt out. I mean, as I said, Congress has all kinds of protections for do not call lists and whatever. People should be able to protect their own information. Just because I may give information to my employer doesn't mean that I want the government to mandate that now my information goes to a whole host of political parties and actors against my will, and I should be able to control the use and the dissemination of my information, and there is zero protections for that in this rule.
Thank you, Mr. Taubman.
Yes, sir.
Mr. Allen, I'd also like to add, in response to some of this about unequal access, since I do a lot of election cases, certifications, decertifications, what have you, I've seen in more and more campaigns today websites set up where a group of employees will set up a website. So once they set up a website and the word is out, hey, if you want information about our campaign, you can sign up, you can voluntarily give us your information. It's out there. I see websites in campaigns now constantly, but those employees have the option of voluntarily logging in and giving their email information.
Good point, Glenn. And while I've got you, under the final rule, employees would be required to provide an expanded Excelsior list, including each employee's name, address, phone number, and email address within 2 days of an election order. In your experience, do unions visit employees' homes, call their phones during an organizing drive, or have employees describe these interactions?
Absolutely. There's many complaints of home visits, unwanted home visits, union people parking themselves outside of people's homes, abusive things like that. So there's plenty of access that union officials have and use.
The chair recognizes the gentlewoman from North Carolina, Dr. Fox.
Thank you, Mr. Chairman. Mr. Taubman, in your experience, do unions routinely provide employees they seek to organize information about themselves? For example, do unions disclose their constitutions, bylaws, results of unfair labor practice charges, results of negotiations for first contracts, past records with other employers, bargaining history, and demands that could include grossly underfunded defined benefit multi-employer pension plans, past records of civil or criminal violations and misconduct, and their record toward members ordering union fines and member discipline?
Congresswoman, I can assure you that no union discloses any of that kind of information to any employee. They're oftentimes voting in the dark. If they can get any of that information about the union that covets them, they're very lucky. And they need that information to make an informed decision. And I would just like to quickly add, when employees in a shop seek to decertify a union, they don't get Excelsior lists. They have to go out and try to communicate with their fellow employees. So they are not given equal access in trying to rid themselves of an unwanted union.
I'm sorry my colleague left before he heard the answer to that question. Quick thing, Mr. Chairman, and again, I'm sorry my colleague from California has left when he talks about Orwellian language. I'd like to point out on this same subject that our friends introduced a bill called the Free Choice Act related to imposing unions on employees. And if you want to talk about Orwellian language, I can match title for title any of them they want to talk about. Thank you, Mr. Chairman.
This is the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
For Mr. Taubman, what's the average time right now between a petition and the representation election?
I think those numbers are something like 40 days under current law, 50 days, something like that, which seems wholly reasonable in any election, whether it's a certification or even a decertification.
They give us more than 40 days, and we run. How many cases are delayed, like, and how long?
I really can't speak to those numbers. I can tell you, as I pointed out in my testimony, since I have many clients who try to do decertifications, which you'd think should be dealt with fairly and equally under the National Labor Relations Act, the decertifications are constantly blocked by union unfair labor practice charges. They go on for months and years, and some of that is in my written testimony. And when we asked the NLRB, as part of this rule, to just apply the rules across the board, whatever they were going to be, apply them across the board for certifications and decertifications, we were told, no, forget about it.
One final question. Do we have time? What recourse does an employer have against a false statement a union makes or false information they give?
Well, the law doesn't outlaw false statements by labor organizations. There's no truth in lending law that is applicable to union statements.
This is an employee decision. It's not the union's decision, and it's not management's decision. It's the employee's decision. They're the ones that go in that little voting booth the NLRB agent sets up and marks the ballot, that paper ballot they give them, yes or no. And that's a hard decision for them to make. They make it with themselves, but also in talking with other employees and with their families, because their families could be very definitely affected by this decision. If a union takes employees out on strike, the employer has the right to cease paying that employee and providing benefits like health insurance, and that involves the family. And to give the employees the time to sit down with their fellow employees and their family members and say, is this a good decision for us, for me and my family, seems to me pretty fundamental if you care about employees. Now, if you don't care about employees, if this is all about something else, then you wouldn't be concerned about that. But I think we on this committee should be concerned about employees. And if you're concerned about employees, there ought to be time for these employees to make this decision. And the last point, the third point, that is perhaps the most disturbing is what this rule is doing to the privacy of the American worker. You know, I don't have too many of my constituents that come up to me and say, well, I really would like to have a shortened time for a union election. But I have plenty of people come up to me and say, I'm worried about the way my private information is accessed by people in a lot of different ways. Now, employers have to get certain pieces of information from their employees. Sometimes it's because what we require them to get. And sometimes it's necessary. You've got to make sure you have information for providing health insurance, et cetera. And that information is kept, I'll tell you, in most HR directors' offices, kept in a locked cabinet with severe rules about who has access to it and what can happen with that information. And now we're going to tell employers that they have to divulge that information to an outside entity with no protections to the employee. I think that runs very counter to what we should be doing to protect the working people of America. And if they were here to be able to be heard, and Ms. Crawford, I appreciate your being here, if we had more of them here, I think we'd hear a lot of concerns from them about that. So I appreciate your testimony today. I appreciate the questions that came from the members. I think we have fleshed out this issue very well. I look forward to the action that will be taken on this matter, and at this point, this hearing.